All we're saying is that B3A through D say that the certification determination has to be made by a 3-judge panel, but it doesn't prohibit rehearing petitions by federal prisoners. So it's a difficult argument and a difficult issue, again, that I don't think the court would have to address if it went with one of our narrower arguments.
I mean, what E tells you is when this certification process generally stops. I suppose that's the same point that Justice Barrett is making, and it seems to be slicing the bologna pretty thin to say, well, we'll do A through D, but then we won't do E, even though E basically puts the period on what A through D says. It says, here's when it ends, the certification process.
Sure, Your Honor, we take that point. I think the key word that you just used is process, which is not a word that's used in H. That's a word that's added by the government in its brief, along with the words final and conclusive.
I take the point, but you know, it's what H is about is how something gets certified. So it doesn't seem to be too much of a leap to say when you're talking about how something gets certified, you're talking about the certification process, and that includes sort of the statement which E gives about when and how that certification process ends.
Sure, Your Honor. So again, our argument is based on the full text of H, certified as provided by a panel of the appropriate court of appeals. We think that only covers the provisions that provide for certification. E comes after that determination has been made.
Could you win without the clear statement rule?
I'm sorry?
Could you win